Let's go on the record on cause number DC233156, D3F3 HP Partners LP versus Active Park LLC. Counsel, make your appearances.
Eric Scott for the plaintiff.
Albert Van Huff representing all of the defendants.
All right, let's proceed.
Yes, Judge, this is a motion for summary judgment seeking to enforce a settlement agreement that was entered into in August of 2023. Pursuant to the uncontroverted summary judgment evidence in front of you, only 3 of these settlement payments were made on time. The final settlement payment was due on or before March 1 of 2024. Currently, there is a balance owed under the agreement for the settlement payments of $79,975. The defendants, in their response that was filed on 9/27, judicially admit that they breached the settlement agreement at paragraph 2 and acknowledge that this balance is due and owing. It appears that the only issue that they're attempting to raise in their response is the amount of attorney's fees to be awarded in conjunction with this agreement and the enforcement of this agreement. What the defendants have done is they take you to paragraph 9 of the settlement agreement, which is entitled Cost of Enforcement. It's very clear, Judge, that in this particular paragraph that the party, that is the landlord, which is the plaintiff in this case, is entitled to recover from the lease party, which is the defendants, all reasonable fees and other costs incurred. And it says that's in addition to any rights, relief, or recovery provided by this paragraph, or in addition to any other rights, relief, or recovery that the landlord, the plaintiff, has under the lease, the First Amendment, the guarantees, or the lawsuit. With that said, the evidence before you, which is my affidavit and the billing statements, seeks total attorney's fees of approximately $33,000. I'll get you the exact number, Judge. $33,962.50 with costs of $1,064.54. What the defendants have argued, and it's all it is just an argument, Judge. There's no objections to the summary judgment evidence. There's no controverting affidavit. What they're attempting to argue is that we should only be entitled to recover attorney's fees from July 11th, 2024 forward. What that argument fails to account for, Judge, is A, the additional attorney's fees I've proved up through my affidavit associated with the time and efforts for this particular hearing. B, the amount of fees incurred since, let's just call it 3/1 of 2024, when the final payment was due and owing and it wasn't received. Certainly all the fees from that date forward would be collectible. C, they fail to account for the fact that the collection paragraph allows us to recover costs and attorney's fees relating to the CSA, that is the confidential settlement agreement, and the enforcement of that confidential settlement agreement. And those particular entries would go back as far as, according to mine, I'm looking at 8/17 of 2023. So, Judge, I renew my request for the award of the undisputed amount of $79,000 and $975 plus attorney's fees of $33,000.
Response?
Yes, good morning, Judge. So the underlying case here was a commercial lease dispute regarding a space that was going to be leased in Dallas for a restaurant by these Houston restaurateurs who normally don't operate in Dallas. And we agreed to settle the case for $570,000. My clients have paid $490,000 of that amount, which is about 86% of the settlement agreement. And unfortunately, in July, we got hit with a Category 1 hurricane down here in Houston that knocked out power for 2 or 3 weeks and put many restaurants out of business for that period of time, including my clients' operations here in Houston. There was spoiled food. You know, the rent doesn't stop just because the power's off. We can't operate our other enterprises down here. So we do, in fact, acknowledge that there's basically an $80,000 balance left on the settlement agreement, and my clients are endeavoring to pay that. They just haven't had the extra money in the operating account to get caught up and pay it off. And so I acknowledge in my response to the summary judgment that there is in fact an $80,000 balance, which equates to about 14% of the total settlement agreement left to be paid. Okay, so then the next issue is attorney's fees. Well, under Stewart Title Company versus IAO, when there's a settlement agreement and for an underlying claim, and then there's a suit to enforce that settlement agreement. In IAO, it was and that's a Supreme Court 1996 case where the Court of Appeals ruled that both parties in that case, an insurer and some insureds, were barred from asserting new claims for attorney's fees for services predating the parties' agreed judgment. And so our settlement agreement that he's discussing the breach of in this case is basically the same as the agreed judgment that the Supreme Court discussed in the Stewart Title case. And so under Supreme Court precedent, when the party seeking to enforce the settlement agreement, they don't get to go back and collect attorney's fees from the very beginning of the case. In fact, the contract, which was drafted by Mr. Scott and reviewed by my office, the provision regarding attorney's fees that he's relying on is called costs of enforcement. And so in the underlying case, there were claims made by the plaintiff. There were some counterclaims for DTPA and to have the contract vitiated by fraud. And all of that was settled by the settlement agreement. Now, I've submitted to the court a proposed final judgment for the $79,975 that's owed on the settlement agreement. And I left a blank for attorney's fees. And, I would propose that the court decide the number to fill in the blank. And I would agree to $10,000. And my clients are going to endeavor to have that entire amount paid off by the time the judgment becomes final at the end of October. I don't know why he's asking for a partial summary judgment in the first place, because it seems like what he's asking for is a final summary judgment on the settlement agreement, because all of the claims that predated the settlement agreement were the claims that were settled. And so that's my position on the case. And my clients, although they got behind, they've been sending in payments. $490,000 out of 570 is not a laughing matter as far as I'm concerned. I mean, that shows good faith on the part of my clients to get this paid off. But I think that plaintiff's counsel is overreaching and seeking his attorney's fees since the beginning of the entire litigation. He added breach of the settlement agreement as an amendment to his petition, by the way. So that's where we stand on it. We could write agreed final judgment on this, and you could pen in $10,000 on attorney's fees. And by the time the judgment becomes final, my clients are going to hope to have it entirely paid off.
So let me ask this, so I kind of understand it. What exactly is the amount of attorney's fees that have been incurred in enforcement of this settlement agreement? It's not 30,000, right?
Well, Judge, no, and just as a point of clarification, counsel is incorrect. First off, the final payment was due in March of 2024. I'm sympathetic to the.
Just answer my question, and then you go into the argument.
Okay. As I have calculated the amount of fees that are specifically that relate to the confidential agreement and the enforcement, that number comes out to be $13,442.50 before I add in the additional fees that I pled for this reply, this hearing, and this response, which is $3,087.50. So
how much is that total?
I believe that total is $16,530.
All right. Do you have anything contrary to that amount, Mr. Huff?
Well, Judge, I would just argue that the fees for drafting the confidential settlement agreement aren't fees in connection with enforcing the confidential settlement agreement.
Was that part of what you included there?
Yeah, it is, Judge, and I'll tell you specifically why. First off, the agreement in place does not warrant a final judgment. Paragraph 9 of the agreement allows my client to recover all the fees from the date of inception, because these are damages that are available under the lease agreement, and the amendment. That's paragraph 9 of the agreement. Now, what's important to remember, Judge, is the release that my client provided in this document is expressly contingent upon full and final payment and compliance with all the monthly payment obligations. Those obviously have been breached. So there is no release by my client. And paragraph 19.1 of the settlement agreement clearly states that if there's a breach, in the event the lease parties fail to comply with the agreement, the landlord can enforce and pursue at its option all of its rights, claims, damages, losses, and remedies, including without limitation this lawsuit. We can enforce this agreement. We can enforce the lease. We can pursue damages under the lease, the First Amendment, and guarantees. So it's still a live case. That's why I have filed a partial motion for summary judgment. At this point in time, my client hasn't made a determination if it's going to seek the additional damages that are available to it under the lease and the lease agreement because the space was damaged by the defendants and they failed to repair it. And so those damages are still in play should my client wish to pursue it.
Judge, I mean, is he seeking to reopen the entire case or is he seeking to enforce a settlement agreement?
I could do both.
Have both.
I could do both, Judge. Pursuant to the agreement, the way it's drafted, that is exactly how it is
So,
positioned.
so we're gonna have a trial in December over the original case?
We could over the breach of the lease, yes, because your
That's-
client failed to comply with the lease, with the settlement agreement. And so
That's just contrary to Supreme Court precedent. In both the Stewart title case and in another case, that's Mantis versus the Fifth Court of Appeals. You know, when you have a settlement agreement, the case and there's a breach, that's the issue before the court. We don't go back in Texas and reopen the entire litigation, especially in view of the fact that they're moving for summary judgment on the settlement agreement.
And Judge, at this time, I'm not reopening the entire litigation.
Okay, so let me just say this.
Okay.
I'm just going to make a very practical decision here. I'm going to kind of give you two choices, Mr. Scott. I'm going to grant either a complete summary judgment if you agree to this for the outstanding balance plus your $16,530, or I'm just going to pass this, let you guys try to work it out, and we'll put you back on the trial docket.
So Judge, as I understand, option number one is that just going to be an order granting the partial motion for summary judgment as
No.
Okay. Judge, you're muted.
Sorry.
It's okay.
Option one, if you agree, would be to give you the remedies under what would normally happen in this kind of thing, which would be I'd give you the cost of whatever is outstanding or the value of whatever is outstanding, which I don't remember what it is, 68,000 or whatever, plus your attorney's fee.
Judge Frost again.
Okay, so then we can figure out what oh shoot, are
Sorry,
you guys still there?
Yeah, you froze when you're beginning your sentence.
Okay, can you hear me now?
Yes.
All right, I'm about to okay. Or I'm just going to put it on the trial docket. You're going to try the whole case and we can figure out
Judge, you froze at the beginning of your explanation of option one.
All right. I'm gonna have to sign back on because there's my VPN just went out. So I'm gonna sign back on. This may take a few minutes. You guys are welcome to talk.
Okay.
Ron, I'm gonna put you in charge. Okay, can you guys hear me okay?
Yes,
Yes, Judge.
Sorry about that. My computer just went out.
So,
So
okay.
you understand the two choices? The first
I- I-
choice is, sorry, go ahead.
No, I was going to say, if I understand it, what you're saying is it's going to be 16,530 plus the $79,975 that is owed. You'll sign an order to that effect, and that, in essence, will conclude this entire case, or you'll deny the motion and
Not denied, just pass.
pass the motion, and it proceeds forward to trial with perhaps hopes that the parties are able to resolve this independently before the trial date is reached. Is that correct?
Correct.
Judge, do you mind? This is, there's something I would need to do in order to confirm my acceptance to the first option without running afoul of my client's wishes. I would like to
Sure.
confirm with my client, on that option one before I either
Yeah.
accept or
Do you
deny
want
it.
to, do you want to take a few minutes and just come back, or do you want to come back at 1:30, or what do you prefer?
You still have an open docket today, right?
Yeah, you can come back at 1:30, or you can just come back in a few minutes. I don't have
Well,
an out. I mean, those are your options. So come back at 1:30 or come back in a few minutes.
I'd like to see if I can come back in a few minutes, and if I'm unsuccessful, then it'll have to be punted to 1:30 if I can't reach my client.
That's fair. All right.
Okay.
Well,
I can just wait I'll wait here.
okay.
Okay. All right.
Perfect.
And I'll just log back in, Judge, when there's an opportunity after you.
No, just mute yourself, and you
Okay.
don't even need to do that.
Okay. Thanks, Judge. Thanks, Mr. Scott.
Rhonda, my computer is still rebooting. Can you tell me the next case?
Yes, just a moment. What's that screen?
It should be a scheduling conference, I think.
Okay, so that's gonna be Albert Kennedy. Let me just double check on this one. Yes. Oh, I'm sorry. The next one is gonna be One Studio Salon LLC versus Julia Alvera. Cause number is DC 2410127. The attorneys are Hill and Mayor.
Is there anyone here on that case?
Yes, Your Honor.
Yes, Your Honor, Scott Meyer on behalf of defendants.
Is this a scheduling conference? I'm sorry, I'm having
Yes, Your
problems.
Honor.
All right, let's proceed. So what I need to know is, when would you like to try this case?
Obviously, I'll defer to Brandon because he's representing the plaintiff. But my thought, this was originally filed in July of this year, and then just a couple of weeks ago, I think the proper plaintiff party in interest was added via their First Amendment petition. So I think if we're looking at the initial filing date, probably July of next year seems somewhat reasonable in terms of a ballpark, but I'll certainly defer to Mr. Shulgin.
Yeah, we're not opposed to that, Your Honor. We would just ask, we feel this case is simple and straightforward. And if we could get it tried even before then, maybe May or June of next year, we'd be open to that as well.
I'm not opposed to a June trial setting, Your Honor.
Okay, June. When in June?
Do we know, Brandon, I can't recall, did you guys file a request for a jury trial in this case?
We did, yes.
Okay. Your Honor, I'm not sure what the court's availability is in June for a jury setting.
We have June 3rd, 16 cases on there, June 10th, 13 cases, June 17th, 15 cases, and June 24th, 15 cases. June
So
10th.
June 10th, then would June 10th work for you guys?
Yes, Your Honor. June 10th works for plaintiffs.
Yes, that works for us as well.
Perfect. All right. Would you guys like to
Mediator.
yeah, a mediator?
I think we might be able to agree on a mediator on our own. And in
Well-
fact, I believe that there are currently discussions amongst the parties on selecting a mediator. So I think we're able to do that on our own, Your Honor.
We're gonna pick one now, and then you can substitute later if you'd like, but we want to get that taken care of today.
Okay, Your Honor.
Understood, Your Honor.
Who would you like?
Mr. Mayor, do you have any suggestion?
I'd be really good with anybody at Burden Mediations. Your Honor, if you've got some folks on the Burden list.
Oh yeah, they're Ken Rubenstein, King Pfeiffer, Jim Jordan, a lot of great mediators over there.
Yeah, Judge Pfeiffer, I've mediated with in the past and very comfortable with him. But any of those folks, Brandon, do you have any proclivities one way or another about those folks?
No, and we have no objection.
So you want King Pfeiffer?
Yes, Your Honor, that'd be great.
Okay, great. We're going to go ahead and appoint King Pfeiffer. Anything else we need to chat about today?
I want to make sure, as I'm looking at the proposed scheduling order, obviously the dates are tied to the trial date. There's a couple on section 4 in terms of number hours of deposition time and number of interrogatories. Those are blank. Would you like us to confer and submit something?
It's up to y'all. I can rule on it, or if you got, I'd rather you reach an agreement.
We certainly can, Your Honor.
Do you feel like you need my help with that or no?
I don't think we do, unless Brandon, if you have anything. Otherwise, you and I can confer after we're done here and get this filled out and submitted to the court.
Yeah, that's perfectly fine. I think we can come to an agreement.
Okay. The only thing I like to have in the agreement in the scheduling order is that any dispositive motions need to be heard at least 30 days before trial.
Okay.
Yes, Your Honor.
Just to make sure that's in there. All right, guys. You have a great rest of your day, okay?
All right. Thank you, Your Honor.
You
All right. McKnight versus Ranger Alternative Management. Anyone here in that case?
Yes, Your Honor.
Are both sides here?
Jamie Welton with Dwayne Morris on behalf of defendants Ranger Alternative Management GP, Ranger Alternative Management 2, and Ranger Capital Group Holdings.
Steve Aldis for the plan.
All right. What when do you guys want to put set this for trial?
I think that anytime in the summer would be great.
Okay.
I think that's woefully premature, Judge. I think we need at least 18 months. We have numerous parties that are out of state that we're going to have to subpoena. 3 of these parties, at least from prior litigation, we know to be fairly obstreperous. We've had to get contempt orders against before for failing to respond to subpoenas in a case with this plaintiff. So I anticipate having a little more time needed to compel compliance of some of those parties. So I think we would be better off putting this trial sometime in either December of 25 or January, February 26.
Well, I disagree with that, but this is an indemnification case based upon a contract between the plaintiff and the defendants. I think that's a little bit blown out to say that he's going to do all that discovery.
Your Honor, if I may, only because I know you have some history with this. And by the way, it's good to see you again. It's been a while since I drew your court.
Yeah.
I'm glad to be back.
This is both of you, good lawyers on both sides here.
This is a little Pat Doherty light in terms of the type of dispute.
Okay. Okay.
I represent a registered investment advisor. Mr. McKnight was a limited partner in that advisor company. They separated for a variety of reasons, which we don't need to get into here, but suffice to say, it was very acrimonious. Our former limited partner got into bed with an adversary who then funded his litigation against our client. when our agreement with our adversary settled. He stopped funding the litigation with this party and this limited partner, and that case subsequently settled. We've then had a disgruntled limited partner on our hands ever since. We've been in at least one other piece of litigation with him. This is now a third. So we have some related case issues as well, but at the end of the day, I think we're probably both happy being in your court. And so one of the things we have to do, and we're going to have counterclaims in the case. We've not submitted them yet because one of the defendants that is named in the case is called Ranger Direct Lending Fund, now known as the Ranger Realization Fund. This is an investment fund that was a client of our my clients. This is essentially a fund that was managed by Ranger Alternative Management too, but they're English. We're traded on the London Stock Exchange, so they're a foreign entity. They're going to have removal rights. I've looked at the docket. I don't think the plaintiff has even issued a citation for this entity, let alone tried to serve them. So that has to happen, and then when that does happen, if it happens, that entity will have the right to remove the case. So knowing that with the context, again, we're going to have to not only wait for those things to happen, but we're going to have to issue subpoenas to a bunch of our former adversaries who funded Mr. McKnight's litigation, who may be funding it again today, as that adversary is under investigation by the SEC. There's a current pending SEC lawsuit against that adversary, and we are identified as a victim in that SEC civil proceeding. So a lot of things underneath the surface of what Mr. Aldis says is just a basic indemnification claim. We'll have a series of counterclaims back against Mr. McKnight, but until all the parties are here and settled, we can start getting some of the discovery ongoing. We're not really going to be in a position to pursue the case in the manner that it needs to get pursued. And so I think it's just silly to set the case for 9 months when we know going in we've got a foreign entity that hasn't been served. We have at least 8 non-party subpoenas to issue, 4 of which are out of state, 3 of which
I get it. Mr. Aldis, what do you, that does seem a little premature. Do you want to shoot for maybe January of 2026, or maybe, I don't know.
Well, so everything he just got through saying was handled by a settlement agreement between the parties. So this is really a suit to enforce the settlement agreement. And to say that all this other crap, that was all part of the settlement. So Your Honor, if we're going to do it the fall of 2025, that would be great with me. But and the foreign entity, I'm not going to serve them. Their name's just going to be on there. I'll file an amended petition, take them out.
How about let's do October. How about October 7th, which is exactly a year from now?
That's good with me.
Yeah, Your Honor, obviously we're fine from an availability standpoint, but that leaves about 9 months of discovery in this case, which is, I don't think
let's see how it goes. If it turns out you need more time, we'll talk about it. Who do you want to use as a mediator?
We're open. I think we would use Chris Nolland on this one. He mediated the first suit, so I think he would be best served to mediate this one as well.
How do you feel about that, Mr. Aldis?
I guess it's all right, Your Honor.
That was an interesting sound. But he's a great mediator. But yeah, okay, let's do Chris Noland again. And anyone else? Anything else we need to chat about?
I do have to take issue with what Mr. Aldis just indicated, that he's named a party that he's never going to intend to issue a citation to or serve in this case. I don't understand the purpose of that other than to create an issue between that entity and my client. which I don't think is made in good faith. If he's not going to pursue claims against this party, he should non-suit them from the case, and they should be removed from the caption.
I think I said I was gonna file an amended complaint and take them out, so.
It's not something I can really rule on today. We're just doing a scheduling conference, so, let's address that when it comes out. Okay,
Nothing
All right.
further on our end, Your Honor.
all right, guys, you have a great rest of your day.
Thank you.
Judge,
What'd you say?
so Judge, this is Eric Scott. I'm back on.
Okay, great.
I've talked to my client and the option one is the preferred option.
Okay.
What I'd like to
You
do,
guys-
what I'd like to do, Judge, is present a revised final judgment for you to sign.
That was exactly what I was going to suggest. Go ahead and give me a revised judgment that is agreed as to form, that this is a final judgment with the amount of attorney fees we've discussed. Mr. Huff, you can sign off as to form as well.
Let me ask you,
and-
Judge, some guidance on the agreed as to form. I don't know that we're going to agree to everything on that. First off, I have non-suited A-Life from this case some time ago. I do not want to have a final judgment with A-Life in it. There's been some threats that A-Life might go into bankruptcy, and I don't really want to chase this in an AP or some other bankruptcy matter. So,
I don't.
okay, so that party will be excluded. And I want to make sure that Mr. Van
Well,
Hoffman.
are they still an active party in this case?
They were
No.
non-suited.
Yeah, they were
Yeah, so
non-suited.
they would, just include that in the. I did a CLE on this recently, and so I'll kind of take a little snippet from my CLE and kind of say it now, is that on this type of judgment, I'd like it to be as clear and as clean as possible. And so one way to do that would be that it's clear that you're non-suiting that you included that you previously non-suited. Is it
Okay.
A-Life? Is that what you said? A-Life?
Yes, sir. And I'll put that plaintiff's non-suited A-Life on, and I'll put the date in there.
And that you are non-suiting any remaining claims in this case, any claims of any other claims of any, and that this is a final judgment.
All right.
Should we
And
call this an agreed final judgment or just a final judgment?
No, unless you agree to it, but it might make it cleaner if you agreed to it, but it would be summary judgment order if you don't agree to it, but it would be a final judgment based on a summary judgment.
Albert, let me ask you this. Can we enter into, can this judgment contain a deadline for this final payment as well? Because we've been waiting a long time for this.
Well, once it becomes final at the end of October, you can get writs of execution or whatever, but I can tell you that my clients, I mean, they're 86% paid off. It's just, they don't have the money to pay it, to send you an $80,000 check today, but I think they will by the end of the month, but that's the best I can do. We're kind of splitting the difference on the attorney's fees anyway, and I'm trying to cooperate with you.
I understand. No, I mean, my client's been waiting since March. I just want to see if we can put a finality on this one, Judge, so I don't have to continue to pursue and pursue and pursue.
I mean, this isn't a settlement agreement, though. It's a judgment.
To judgment, yeah. So you can enforce it. You can
Understood.
receiver. I mean, just
I was asking if Mr. Huff, if he would agree to that, we could put it in there, but if not, I understand.
I'm sorry, I can't agree to that, but I'm going to try to.
Can you at least agree to the judgment? Just do. I mean, what makes sense to me would be for everyone involved, and I think it'd be everyone's best interest if you guys just submitted this as an agreed judgment with the amount of attorney's fees that I said and the amount of outstanding, and then it can be enforced however it's enforced. You know what I mean? That makes the most sense. If you can't agree to that, Mr. Huff, then we'll do it the other way.
I can agree to the 79,975 plus the 16,530 in attorney's fees. And by the time it becomes final in 30 days, I'm going to try to have it paid off. He can't get rid of a garnishment or rid of execution until 30 days anyway, even if it's agreed. So that's where I'm coming from. But
you guys talk about it. I think we have you're 95% of the way there. I think this is a good solution, and but you guys have a great rest of your day. Okay.
Thank
Okay,
you, Judge.
Judge, thank you.
Thank
Albert,
you.
I'll send you
Get that to, oh, one thing, Mr. Scott, I forgot
Yes,
to
sir.
say. It's very important. At the beginning of the order, say that this was heard on October 7th over Zoom. And make sure you get that to me by the end of the week.
Okay.
Okay.
Yes, sir.
Thank you, guys. You have a great rest of your day.
Good
Thank you.
afternoon, gentlemen.
Take care.